Hi everyone, and welcome to our Facebook Live this month for the Art of Estate Planning. My name's Carrie Payne. For those that don't know, I'm filling in for Lucke while she's on maternity leave. Today we've got a really exciting topic, and I say that noting that I'm speaking to the right audience when I say exciting topic, because if I said that too loudly outside of this little office or on this call, we might be looked at with a bit of a side eye. But today we're talking about advanced social security for trust companies in estate planning. And I'm so excited to have Michael Miller here with us today. Michael, if you want to tell us a little bit about you and how you came to love this topic.
So I have a financial planning practice here in Canberra, which is combined with an accounting practice as well. It's a good question. I can't remember how I first sort of came into contact with social security rules and trusts and things like that. I genuinely can't, but I think it's a really under sort of practiced area. It tends not to come up too often. And the thing that I think we'll sort of run through, I find interesting, is the structure of the rules and the powers and what that means you have to do if you do have a client who has these and you're dealing with, say, retirement planning or estate planning or aged care and things like that. I think it runs a little bit counter to what people might expect is the ordinary operation.
Yeah. I think it's something that, as I said, when we're in this field, it's so invaluable to know some of those mechanisms, because they can have such huge effects on the practical outcomes of things, and so therefore we should be considering them in the planning stages. I should say too, for everybody, please let us know that you can hear us. Okay, I know we had a bit of a tech difficulty last time, so great. I've got some comments coming up, so that's wonderful. Please feel free to send through your questions. We love questions, and Michael doesn't want to be at the behest of my sole questions, so make sure that you fire them through as you think of them. Otherwise, Michael, I'll let you take the reins.
Yeah, terrific. So really there's two main parts to what we've got here. The first is just how those rules actually work for social security in terms of the assessment of trusts and companies, and then sort of looking at some cases where that's actually been applied to real circumstances, that we can start to understand a little bit how that might actually apply when you're dealing with somebody there. So I think just a quick sort of reminder and background too is where this can be particularly relevant to clients is when we talk about social security rules. The most obvious one is around people who might be in retirement and have age pension entitlements. But the other one that is sort of quite closely linked is anybody who requires residential aged care. Is that whole system of what somebody pays for their care flows through from a lot of the social security assessments of what somebody's assets and income are. So that's you may often be dealing with somebody who might be over particularly the asset thresholds and not in receipt of an age pension. And what they can sometimes do is nearly lull them into a little sort of false sense of security that none of this matters, because it doesn't for a very long time, but then if they need care, then it can very rapidly. Just very quickly, there's a couple of sort of basic definitions in the Social Security Act of what is an asset and what is an income. And what that plays into is the entitlement for people's benefit. There's a qualification requirement. So for age pension, the first one is just reaching the pension qualification age. But then there's this means testing, so working out what are the assets and income that a person has to determine, do they get a full payment, a part payment, or no payment at all. And they're relatively sort of straightforward, simple, ordinary definitions, and that picks up pretty much everything. But what it doesn't pick up is these other entities, so primarily companies and trusts. So that's where the Social Security Act has this Part 3.18, which starts to bring in, a way for those trusts and companies to be sort of recognised and assessed under that social security system. Because otherwise you'd just be looking at having people transfer their money into these entities to qualify for a greater level of payment or something like that. So that's why that's sort of in there. And it's effectively this 3-part test. So the first part, and a lot of these rules are somewhat replicated across companies and trusts. So the first test is this question of, is it a private trust or a company? It then moves into a test for, is that controlled by the relevant individual? And then if you've sort of gone through those tests, there's then an attribution of the assets and the income of that trust back to the individual who might be applying for or receiving a social security benefit or getting some sort of subsidised aged care support as well. So the first part of that test is just looking at, is it a designated private company or trust? So for companies, if you satisfy 2 out of the 3 tests here, you will be a private company. And what you can sort of see, the revenue under $25 million, gross assets under $12.5 million, fewer than 50 employees, if we sort of flip that around, is it's largely looking to exclude really large companies. Nobody who's a shareholder or a director of Woolworths ought to be attributed all the assets and all the income of Woolworths for any sort of social security assessment. So it's that first test is it's just sort of excluding very, very large companies where realistically no individual is actually going to have that sort of level of control. And then we see this a lot in a lot of social securities is there's actually just a very broad power for the Secretary of the Department of Social Services to just basically make a determination that you are or you aren't. I mean, I think I've not seen any evidence of that being used, but you can just imagine some scenario where somebody just tips their gross assets just over $12.5 million to say, I've beat the social security system. It gives them a power to say, well, no, that was contrived. We can sort of bring it back in. I mean, the reality is, if you're in any way involved with a company with assets over $12.5 million, you're probably going to sort of be over all those thresholds somewhere else anyway.
Would be a good problem to have, wouldn't it, Michael?
They're probably not looking for an age pension or anything like that. And a similar set of rules for trusts. Superannuation funds are trusts. They are assessed under social security law, but not this part. So it just straight out excludes those. And then again, you're really sort of looking here at really quite widely held trusts. So not something that is really the assets or the income of that individual or a significant person. It's just an investment in something else or the like there. So that's when you're looking at sort of individual clients, that first stage of the test is normally pretty uncontroversial. It's really only some quite small sort of, you occasionally see a property trust or the like there that might sort of fall under some of those different rules, or it might just make it out because of the number of unit holders or something like that. But stage one's normally pretty straightforward, pretty simple. The stage 2 is where it starts to get a bit more interesting. And this is where there's 2 key tests that apply to that. There's a source test and a control test to sort of start to decide if you meet this definition of being a controlled private trust or company. So first of all, the source test, a company or trust will be controlled by an individual. If the individual transferred funds or services to the entity, this 9 May 2000 is when they changed old rules for assessments of trusts and companies, but by now, I don't think we're ever going to see anybody who, where the date sort of really changes the treatment. And basically, if that would, if assets were transferred in for no consideration or less than arm's length amount. So basically, again, that's that first test is if you've just had $1 million and you've just transferred that to a trust, you very clearly sort of met that source test. The only interesting part that I've sort of highlighted here is the all services part of that definition. That a lot of us sort of listening here, of course, are might be undertaking services on behalf of trusts that or companies that we're connected to. Again, we'll sort of run through that. If you're that close to it that you're doing things for free or for not market costs, you're probably going to get caught up somewhere else in the rules here. But it's just an interesting one that capacity sort of sits in the rules there. You've then got the control test. So this is where there's multiple tests that are sort of exist here, and we can see greater or equal than 50% of direct voting interests held by the individual and their associates. So if there's only one shareholder and it's you meet the control test. If there's greater than 15% sort of direct control interests, and then there's also these more vague tests around the company being sufficiently influenced by the individual. And then it also starts to bring in, if there's multiple layers of entities there. And then the last definition is exceptionally broad. It just talks about if the individual alone or together with associates is in a position to exercise control over the company. And we start to see this in some of the decisions is where that gets applied. And a similar sort of test here for trusts. So, but then it's obviously looking at some of the more formal roles with trusts in terms of if an individual or their associates is a trustee, but it can also look at if they're an appointer or if they have a power to vary the trust deed somewhere. Again, we can see some I describe very broad sort of categories here. If the individual and their associates have greater or equal to 50% of the beneficial interests in the corpus or the income, it doesn't need to be both. And again, if a group is able to control or enjoy the benefit of the corpus or income of the trust. So, even if you imagine a holiday home that's owned by a trust, even if the individuals, if somebody has the keys, is able to access and use that property on a regular basis, regardless of whether they're actually a beneficiary or anything like that under the trust deed, that can still, that control test can still be applied. And the real key to how extensive that control test is this associates definition. There is nearly no way to avoid this. So it talks about a relative of the individual, an entity that is expected to act in accordance with the wishes of the individual or their associates, business partners, spouses, children, and companies and trusts that are controlled as well. So, looking at the definition of relatives, we've got a spouse, a parent, grandparent, brother, sister, uncle, aunt, nephew. We can all sort of read it on the screen there. And then even sort of, E brings in the spouse of any sort of person, covered by D, and then a child of any of the above. So that there's nearly nobody that can really sort of escape this, how extensively this relatives definition can go through the family tree and then feed back into the associates rule. My favourite sort of, I think, example of this, I mean, it doesn't apply because it wasn't in Australia, but, I think it was Arnold Schwarzenegger was married to one of the descendants of the Kennedy family, had a child out of wedlock with, I think it was the nanny or the cleaner or something like that. If that child was creating a trust in Australia or applying for a social security benefit, the relatives and associates rule basically implicates the entire Kennedy family dynasty, just because one of them married somebody who had an affair and had a child out of wedlock. So I don't think any Kennedys are applying for an age pension benefit, but it just captures such a wide net of people. I was having a discussion with another financial planner just the other day, and they were talking about where there was a vulnerable beneficiary of an estate, and there was the potential that the vulnerable beneficiary, there may be a trust set up for her benefit with the brothers as the trustees. And she wouldn't have any sort of formal control, but we can see through the relatives is a brother is very clearly in that relative definition, so therefore sits in the associates definition. So control can be attributed to the sister because her brothers control the trust as trustees or appointers or anything like that. So it's very, very extensive. And this is my other example of these are all people who meet the associates definition. The child of your spouse's second cousin's spouse, the trust for which your business partner's spouse is appointer, and the company controlled by your grandchild's stepchild. So just answering one of those questions is the test is for Social Security rules. Where that most commonly applies is people applying for something like an age pension or a disability support pension. But the other part that it can apply to is those Social Security rules determine what people pay for aged care as well. So that not so much the access to the aged care, but what they'll actually pay in terms of how much is subsidised by the government and how much is paid by the individual resident. So this is where it's at stage 2. It's if you've gotten past stage 1, it's not a widely held trust or a really sort of big private company. If you're anywhere near it, stage 2 will just about sort of grab you in a way, and to the extent that I'm certain that there are a huge amount of undeclared sort of trusts and private companies out there. I mean, quite reasonably, these people wouldn't actually know, that is said, their aunt's, husband's child from a first marriage had a company. So it's not so much an issue for them, but it just sort of again highlights that if it is something that you actually do know about, nearly by virtue of the fact that you know about it, you probably actually met all those tests in stage 2. And the last stage of it then just says that you are an attributable stakeholder. Now, the key, and this is where I think these rules sort of run a little bit contrary to people's, say, expectations at times, is what those rules say is once you are an attributable stakeholder, you start at 100% attribution. So if there's this sort of, let's say it's a trust out there, somebody somewhat close to you controls it, you are attributed 100% of the assets and income of that trust for your own assessment. Once you've met that test, there is then a discretion that the secretary has to lower that from 100%, but it starts at 100. So even if you're talking about a trust with 4 beneficiaries, it's really clear that you're not the sort of the 100% sort of recipient of it. The way those rules work is it starts at 100, and you've then got to effectively sort of argue your way back down to something that might be more reasonable as a percentage of attribution. And there's quite a wide sort of set of criteria, but very broadly, they're looking at what is your actual involvement in day-to-day management and decisions. What benefits have you received in the past? What might you get in the future? What contributions did you make? So there's sort of 3 sets of principles that are listed there, which are basically all the things that the secretary must consider in applying that discretion to reduce the attribution from 100%.
Michael, can I ask a question just based on the relative stuff? Because my mind's spinning about, who could be a relative or an associate of mine under those definitions. Do you see a lot of enforcement action, so to speak, on situations that people had absolutely no idea about? Or is that something we're going to be talking about in the cases part? Or
yeah, no, I think particularly that question is because it's all a bit of a self-declaration system. So this is what I say is yes, you sort of have to tell Centrelink, hey, there's a trust or there's a company here for them to sort of start assessing that. So where you start to think of some of those ones where the rules would say this is actually attributable to you, but the individual just wouldn't even know that it exists. Is what happens there is just nobody knows any better. Effectively, there haven't been, and we'll come through the cases. One of them, the issues in then trying to sort of give somebody some advice and clarity about this is there's not a huge number of there's not a huge number of disputes about those decisions, and this is the only place we actually get to see the outcome. So in contrast to things like tax, where people can actually go and apply for private binding rulings, and an anonymised version of that gets published where people can see. What happens with Social Security is that they won't assess a hypothetical. You can't sort of say, hey, somebody's thinking about putting in place this trust structure in their will. If they pass away in 20 years and then one beneficiary gets this much, how would you assess that? It's only when you get to the point when you're actually making that application and you're saying, hey, here's what's there, here's the details of this trust. And what happens is, of course, that's made to Centrelink. Some of the cases that we're going to go through are from the Administrative Appeals Tribunal. But to actually get there is what has to have happened is somebody's sort of put in the documents to Centrelink. Centrelink's made a decision. They then have, if you disagree with that, there's an internal review called an authorised review officer. If you disagree with that, it can then go to what used to be called the Social Security Appeals Tribunal, but is now the first division of the Administrative Appeals Tribunal. And if you still disagree, or if somebody sort of appeal that, is when it gets to the second division of the Administrative Appeals Tribunal, which is where we actually get to read about it. So there's a lot of stages there where people may have sort of put in an application. I don't think that there's a wide awareness of the rules, sometimes even within Centrelink, because it sort of has to go to their complex assessment areas. So I think a lot of decisions probably get made and nobody ever actually gets to see, particularly that question of how that discretion gets applied. Coming back to that original question is there's probably just a lot of non-declaration of ones that would probably end up being attributed at 0% anyway, but just nobody knows that it's there, or they have a vague idea that it's there and it's so far removed from it that they sort of don't even think about it as something they should sort of include in those declarations as part of an application. And finally, the other one that we've seen too is where some other people might be brought into this in terms of residential aged care, is often people pass away quite rapidly in residential aged care. So I know I've had one case where there was a trust. We made our submission to Centrelink about, hey, this is how much we think should be attributed to this individual. She's going into care, and effectively she passed away, and Centrelink just wrote back, said, well, she's passed away, we're not going to bother doing the assessment. Sort of too hard, doesn't matter anymore. You often sort of may not actually get through those processes, within somebody's life expectancy if it's aged care is the first time that they're actually applying.
Yeah. Which is disappointing if you put all the effort into trying to prove the point and not really have an outcome to be able to rely on later.
Yeah, okay, it does make it exceptionally difficult. People quite naturally would like some certainty from you on how will this be assessed, and all you can really actually say most of the time is, hey, we will make the most sort of cogent submission we can, but actually we sort of don't have any idea. And I think some of the cases will illustrate a little bit of sort of how actually how arbitrary that can be in some ways. The first one here, so a decision of Whitby. I don't know that a lot of this sort of the screen size is quite big enough, but this was a case of a testamentary trust set up for an individual, and again, I don't think she particularly had a wide awareness of what she was doing when she went and sort of put in all her sort of applications. But there was a period of, I think it was about 12 or 14 months of the estate being administered before the testamentary trust sort of came into being. What was interesting is in that case, Centrelink tried to run the argument that the trust existed the moment that the relevant individual passed away, not once the estate was finalised and administered. What I think this really does sort of highlight too is just how some of the people making the decisions within that organisation may not have a really good understanding of some of those principles, because they fairly substantially lost that argument in this decision and were sort of criticised for, probably rightfully so, of how did it get to, because remembering this is sort of about the third or fourth level of appeal, and it was uncontroversial to the tribunal member that the trust doesn't come into existence the moment the person sort of passes away, and yet they had, I think a very senior solicitor trying to argue that point on Centrelink's behalf. But so there is even just that, when you're making these declarations, working out, well, when does it actually need to be made? I think the only other thing to take out of that is there is in Social Security a very broad anti-avoidance measure. So you will see that in their guidance about estates and things like that, that they often sort of talk about a 12-month period in terms of, I think the case that they're trying to sort of make or promote there is, if you've just actually delayed finalising the estate for 4 or 5 years when there's no reason to do so, just to sort of keep that money out of this trust assessment or anything like that, then we can probably use our anti-avoidance sort of rules to say, no, you're just trying that on. But there isn't actually anything in legislation that says 12 months is actually the time, or anything like that. So that was, we'd be sort of explored that pretty well.
Michael, with that case example, do you think, just I'm spinning my head here, spinning for everyone that's on the call, because I think that might be something that people use quite often. Do you think that the time period, I know we talk about that year, but I know the tax department has that 3.5 year is a 4-year rule about when that nasty tax rate comes in. Do you think that's a better watermark that you could rely on, or?
Look, I think it's probably that, what is the reason for the period of time? And that's where, if you can actually point to something else, I mean, obviously, estate disputes is a really obvious one, is if the estate is in dispute for 3 years, which is not impossible, then again, you've probably got a good reason. If there's no dispute, the estate was just made up as sort of cash and a property, again, that's where and there's, say, a single beneficiary, that's where I imagine that if they tried to run the case to say, you're actually influencing and controlling and delaying that for the Social Security benefit, it'd probably be a pretty easy case to make in those sorts of really straightforward circumstances. But as you touched on, there are many, many estates which don't have those straightforward circumstances. And I think it's probably just the case of being able to point to, here are the reasons, and nobody actually wants to delay an estate. So if it is running into years 2, 3, and 4, there's probably some very simple reasons to be able to point to hey, this is why that's happening. There's sort of no clear answer on that one, except for what they tried in that particular one of saying it started the moment the person died was very clearly incorrect. So we had another decision, Huben, where there was, I think it was Jan Huben. He owned 51 of the shares in a company, and his son owned the remaining 49. There was a point in time at which he sold 2 of the shares to swap that sort of 49-51 split across. And I think this is an example too of particularly the role that we can play in terms of giving advice. Is just to highlight. I think a lot of people often approach this sometimes from a sort of a tax or accounting lens, where all of a sudden the 49 to 51 sort of becomes substantial. But we're all, of course, experts in the control test and the associates rule now. So what we're all looking at that is saying, just doesn't matter. the changing of the 2 shares to make a shareholding 51 rather than 49 when it is your son doesn't do anything to defeat that control test. The original decision, and again, this sort of shows a little bit of sort of sometimes the arbitrary nature is they just said, look, it's close enough to 50-50, so we'll attribute 50% of it to you. Jan was trying to argue for 0%, saying, hey, it's not mine anymore. I don't control it. Somebody in that first division of Administrative Appeals Tribunal probably went through a very, very formal process to say, hey, it barely makes a difference if it's 50 or 49. 49 aligns with the shareholding, so hey, why not go with 49%? I think even just thinking about some of the process is there was then a subsequent decision in 2023, so 8 or 9 years after that original decision. And in this case, Mr. Huben was receiving no age pension because of that attribution. And effectively, the decision was actually about a late appeal. But it basically showed that those shareholdings and attribution percentages hadn't changed. So the assessments hadn't changed. And that's where you may have sort of come across or run into your Mr. Huben in 2015, and that's where, if you understand and can explain the rules, you might sort of say, look, there's nothing we can do about the attribution right now, but start to think about what are the changes that might be necessary, because in this case, if you just do nothing, you're going to be back here having the same argument 9 years later, and you're probably absent a change in the law, you're probably going to lose it again. So it is sort of starting to understand what are the actions that you might sort of take or recommend to a client. Then had another one. This was decision McDonald's, and we've got a bit of the timeline there. And again, we can see, and I think this is where we probably most commonly see the decisions coming from, is a lot of people who are perhaps running businesses and small businesses where there's effectively a generational sort of transfer between the business. And so we can see in here there was a number of sort of different changes in shareholdings. Again, I suspect this was quite tax driven, is there was a different class of share created for the sort of the older generation to pay out a dividend for past, which was probably to represent past earnings and things like that in the business. Again, looks very tax driven. Because of the extensiveness of that control rule, it just didn't really make a difference. This case also sort of highlighted what you need to be careful of in sort of winding up some of these arrangements. It is effectively Mr. McDonald, he went through a series of, oh, hey, I don't have control because I've got a different class of share which doesn't have voting rights. I'm no longer the company secretary. It was all sort of attributed, because of the extensiveness of that control test, it was basically, it doesn't matter, it doesn't matter, it doesn't matter. And then he finally sort of severed enough ties. But what they actually then sort of look at that is these deprived asset rules. So they're basically saying, well, look, when you finally severed your control of that company, that was you giving up the asset that was your interest in that company. So therefore, we're going to attribute that to you under the deprived asset rules for another 5 years. So what that one sort of highlighted is there's actually no way to sort of avoid that rule. But there was effectively this sort of 3-year process of where you could sort of see Mr. McDonald, he was trying to sort of remove his control. If he had advice that sort of understood those rules, he could have at least started that effectively 3 years earlier in 2016, rather than it being sort of right at the end of 2019. So, yeah, we're sitting here in 2023. If that had been done at the start, the 5-year deprived asset, that period would have finished. It would now be off the books, and Mr. McDonald would be able to sort of claim his age pension. But still, 2019, which of course is a pandemic ago and a couple of lockdowns ago, it's still actually counting there until the end of next calendar year as well. We then had a case in relation to, this was the estate of a Mr. Paul Sweeney. Also just sort of highlights that just because the relevant person is dead doesn't mean they'll stop seeking to recover what they perceive is an overpayment. And this was an example where there were companies that had undertaken various sort of attempts at business activities, and ultimately not been all that successful with them. But there'd been loans made to those various companies and things like that that were still being assessed as assets. So in this case, there was effectively a shareholder loan of $1.9 million that this company owed to Mr. Sweeney. The company was still around. It had no ongoing business, no assets. It was worth close enough to $0, except for the $4.9 million of capital losses that it had made in those business ventures sort of in the past. There were other people involved with that who they saw some value in keeping the company because they thought they might be able to pump effectively $4.9 million of capital gains through that at some point to use up those losses. But yeah, that didn't sort of help Mr. Sweeney. There are some particular hardship rules where, let me take a step back. One of the keys is even though that $1.9 million, that loan to the company economically, it was not able to be, there were no assets sort of backing it. So you were never going to get your $1.9 million back. There just isn't the provision for Centrelink to look at that. They just say the loan is the loan. That is the value that's attributed. There are then these sort of hardship rules around unrealizable assets. So what they did originally is they granted him a pension because they said, look, that $1.9 million loan, your asset, isn't able to be realized. So therefore, we're going to disregard it. But one of the keys to the hardship rules that are required is that requires that you basically have no other accessible assets. So originally they said, look, you don't have much in the way of other assets, and then you've got this $1.9 million loan you can't recover. So we'll actually let you exclude that from your assessment. But we can see here later in 2020, Mr. and Mrs. Sweeney, they actually received an inheritance. So they had about $200,000 in liquid assets. What that actually meant is they no longer met those hardship provisions. So the requirement to have that $1.9 million loan not assessed, that was no longer possible. You have to meet the hardship conditions before you can have the unrealizable asset recognised as not able to be being realised. So that's where he effectively lost that age pension entitlement, because he in their eyes he now had about $200,000 in liquid assets and the $1.9 million loan. So that's again sort of highlighting is there would have been ways to sort of write off that loan and things like that in the past, and perhaps actually sort of recognise, hey, I'm never going to get this. If done early enough, that might have meant that it wasn't there sort of on the books. Another similar sort of case here, this one of Bell, is that there was a company, again, no real assets sort of behind the company, but there was potentially some value in tax losses there. Mr. Bell had been a director. He retired and then passed away due to ill health. Sitting on the accounts from this company was an unsecured loan to Mr. and Mrs. Bell. So, of course, it was also relevant in this case that the loan was recorded as being to both of them, not just to Mr. Bell. There were various sort of agreements along the way, selling some of the shares. So Mrs. Bell was effectively trying to, wind this all up, say, hey, I'm never going to recover anything from this, so let's just actually clear it from the books, so to speak. She got virtually no money for doing so. That actually still was applied, and this is sort of where the definition is ordinarily assets look at effectively what is the market value. So we're often telling clients just in relation to you have to declare the value of your home contents, but your couch isn't worth the $2,000 you paid to Harvey Norman for it yesterday. It's the $150 that you would be able to get on Gumtree from selling it today. That's a broad rule that applies to assets, but there's a specific section of the Social Security Act for loans that just overrides that. Just says, no, the unpaid amount of the loan is the value of the loan. And there's been a number of sort of decisions which have tested that, and they basically, it's very unsympathetic. Says, look, the Corporations Act requires the company to properly maintain its books. So, the fact that the company was still sort of carrying this loan as owing to you, too bad. That they didn't test sort of any sort of argument that in this particular case it was actually Mrs. Bell who hadn't been a director, so she wasn't the one who actually had any sort of Corporations Act obligations. But again, it's just that thing of if somebody had been able to identify, hey, this is an issue, it potentially could have been written off well before anybody was eligible for an age pension or was going to make an application there. Or even if you hadn't been aware until somebody was actually at that point of applying for a benefit, you can at least make the decision to say, well, let's start writing that off now. It's still going to exist for 5 years, but at least we've started the 5-year clock ticking.
Michael, we've got a question here from Nick Donnelly, who's a financial planner down in New South Wales from memory. Sorry, Nick, you're in the wrong state. I think it was the case before the estate of Sweeney. Sorry, I just don't remember the case name. He just wanted to know how Centrelink came to the conclusion that that particular man ceased to be, that he ceased to be a tributor.
Yeah, so I think in that way, I think this is the the McDonald or the one before that. The
one before, I think it's Donald, that one, McDonald.
Yeah, so I'm going a little bit off memory here, but I think he effectively actually he went through the stages of all those resignations, and I think he did transfer all the shares. I think there was effectively, they asked him to write a letter to Centrelink saying, hey, I've taken all these steps, nearly sort of saying, hey, I promise I don't have any control. At which point they sort of accepted that. Although, again, it is interesting, right? Because under that control test and the associates rule, is strictly speaking, he still met all those requirements, but just by virtue of his son. But so probably again sort of highlights that it can all get a bit arbitrary. Like, I don't know that he did cease being attributable, but that's the way they sort of applied it. This decision of Snow was just an interesting one. Effectively, there was a settlement deed, which meant that the trustee was the only beneficiary. So he was actually able to show, well, the trust has ceased to exist. So therefore, it shouldn't be assessed or attributed as a trust anymore. Again, that's where I've just sort of made that point, is that there is an anti-avoidance measure that if we're actually just trying to contrive these sort of situations to get a better assessment, that's probably not going to work. But if there are genuine scenarios where a trust or a company has ceased to exist, again, I'll say that can be recognised, but also again recognising here that because we can read it in this decision means that it went through about 3 or 4 levels of appeal before it actually got to that decision. So you can get to the right place, but it's not a quick journey. And my favourite, man, when it comes to the attribution of private companies and trusts and social security is a man, Mr. Johann. No, it's not von Hofel, it's just Hofel. He has had 4 runs at the Administrative Appeals Tribunal, the 2nd Division. I can tell you that the last one, so our February 2023, the decision effectively says, we now consider you a vexatious litigant, go away. So he's none of them would you describe as exceptionally successful, but certainly the 4th one was the least successful. Mr. Hofel does also have a very Googleable name. So I've written about some of these decisions in the past. Mr. Hofel did contact me before the 4th one to say he was planning to launch another appeal. But obviously didn't turn out all that successful.
I wonder what he's like after a few beers if he wants to hit the court 4 times.
I think he likes an argument. He's certainly tried. So this is a little bit of sort of Mr. Hofel's family tree. Is there's Johann, sort of the let's call it the main actor in this play, but there's then so his wife and actually his son had passed away, but he had a daughter who survived, and it then sort of relates to her husband and then children that they had both together and from previous relationships. So I'll go through my timeline here to sort of make sure I've got things right. There was originally a company, Chilcotin, that was incorporated. That there was then the Chilcotin Trust set up with the company as the trustee. There was later on, so this was originally about 1977, in 1991, a company that was incorporated, and that was owned by the trust effectively. And then there's been various sort of distributions and loans back from those distributions that have been made between the various sort of beneficiaries along the way. So if we start to remember, particularly our control rules, is every entity here easily passes the control test. Chilcotin Proprietary Limited, over 50% of the direct voting interests were held by individuals and associates. It started out being Johann and his daughter Andrea. At various points between these decisions, he's tried to transfer his ownership to Conrad, who was Andrea's husband. But as we know, your daughter's husband is still an associate. And also Johann, he remained as a director at various points in time, and so they actually looked at what was going on, within these trusts and these companies, even that extent of the tests. And Johann was effectively the main sort of director of it all, because he's the only one who actually lived in Australia. All the other sort of beneficiaries and directors and the like were actually all in Germany. So that was a private company. That then easily makes the trust a private trust. Again, whether you look at the entitlement to the corpus or the income, or the fact that the company controlled the trust as the trustee, sort of comes into the nest, the test, and then Gemidin again meets that controlled private company definition by virtue of those other controlled entities holding the shares. Again, that's where they also looked at Johan being the only onshore director, and all these various entities were ultimately really doing is managing and maintaining a share portfolio. And Johan was the one, Morgans were the stockbrokers, Johan was the one who was interacting with them. Nobody else was actually talking to them about what they might buy or sell or anything like that. So
I think it's sounding pretty much like a business version of the Young and the Restless or the Bold and the Beautiful, with all the names and all the relationships.
Yeah, look, I think the Bold and the Beautiful was a few more sort of cross relationships in there, but yes, they would certainly have a lot of difficulties with the associates rule. So one of the keys is this was one of the decisions is effectively that declaration of effectively what Gemidin held. And the main thing there was effectively the share portfolio worth about $1.4 million. But it's sort of, in the interest of time, I won't go into too much detail on it. Through those sort of timelines, is what had happened is the beneficiaries had received distributions out of the trusts and then loaned it back to Gemidin. So that's where these loans are sitting there on the balance sheet. So actually, if we're deducting the loans from the assets, the whole trust was only worth about $281,000. If all those loans were repaid to the beneficiaries. Again, they really like to bring things in here. There's specific rules around where a loan is from a minor. So I think it's Oscar and Hugo, who we both see carry a $315,000 loan each. They were minors. There was no loan agreement made. It was all sort of done by their mother sort of on their behalf. Is they used the gifting rules to say, well, actually, that's not a loan, it's a gift. So rather than the value of Gemidin being assessed as that sort of $280,000 of net assets, those two loans, which are a big part of it, got added back, and all of a sudden it's being assessed at $900,000. So I'll just see if it sort of is pointed out here. Again, I think Johan's sort of overarching and consistent argument was, hey, I'm one of 6 potential beneficiaries, so therefore I should be assessed at 1/6. At various stages, I think he got a 50%. I think he got himself down to 33.3% at one stage. They're all actually very arbitrary. I would actually probably argue that these loans from the beneficiaries were not loans that they were actually going to call. It actually just looks a lot like if you imagine a grandfather who had a $1.4 million share portfolio in his own name. And it was effectively saying, hey, look, I won't draw down on this, and on my death, you'll all inherit this, in which case Centrelink would assess it at $1.4 million. So you could make a pretty good argument that where he ended up on 1/3 of $900,000 and being able to sort of add those loans back once the 2 grandchildren did actually were no longer minors, it's probably a pretty good outcome, compared to the alternative. But a lot of submissions, a lot of arguments to be had to sort of get there. And as we saw, he's now sort of stuck with his final decision because they're not willing to consider any further applications that he might make. But that they are really good decisions in that they really sort of go through how they've sort of factored in, looking at all these different, not just the broad associates part, which just sort of gets him in at 100% anyway, but they do look at what does the trust actually do, what does it hold, and things like that. So it's useful to see how they've considered and examined that. But then also at the same time that it's then just been a bit of an arbitrary, look, let's pick this percentage because it seems about right when we've weighed everything up at the end of it anyway.
It's like that law professor that challenged the Kevin Rudd payment that he made, the $900 or so back in 11 billion years ago. It's a service someone had to do, but they're not going to be real popular for doing it to set it all out the law. So,
well, yeah, as I said, one of the things is that we just don't get to see a lot of these decisions. So I'm very grateful to Mr. Hopeful for his efforts. But I think just finally is that really is what can we actually do is as early as possible if we can identify that these trusts and companies exist and that, hey, hold on, this can be an issue with Social Security. So it's, you should go and address that. You should work out, again, there might actually be value in them keeping that company or trust around, but we saw through some of those cases that ideally they would have gotten the advice 3 or 5 years earlier saying, you're never going to get this. It's time to start winding it all up. And so that you're not assessed on this for the rest of your sort of retirement. Again, just over time, have these assets and liabilities sort of written down to reflect the real economic value. I think even in that McDonald decision, it was, I think it was, might have even been an auto electrics business. What made up the assets was likely a whole bunch of plant and equipment, which was recorded at purchase cost, not the actual resale value. That again, if that was done, you're still going to get attributed, but at least you're only getting attributed on the real value of them. And of course, it's that key of what I've sort of covered today is the Social Security implications, which can be quite important to an individual. You may have to balance that with tax requirements, with estate plans and things like that. So it's one of those ones that you do want to be making sure that you're not fixing one issue and creating another, because I think certainly on the Social Security side is a lot of them I think you would describe as an accountant has tried to get the best tax outcome, and they probably have gotten a fantastic tax outcome, but just been unaware of the Social Security outcome, which might have sort of negated that. But I think that's pretty much it. That's me.
Thank you so much, Michael. It's been amazing hearing you talk, and I know I've had a couple of people I've been texting in the middle of our presentation saying, are you watching this? This is Michael, and they're, oh, we love Michael, and I can't say how thankful we are that you've joined us today. I know there probably will be a lot of flow-on questions that people might have as a result of this, so you've got your details up here for people that can contact you. Is there any preferred method out of the three, or are you happy for people to reach out to you on anything in particular?
Oh, look, I'm happy with all of them. LinkedIn's probably the useful one. I sort of write about these decisions as they sort of come up, so that's probably the best way to, if you're interested in if Mr. Hopeful somehow manages to get a fifth case up, that's where you'll see me writing about it. So.
I'm grabbing the popcorn as we speak. So thank you again, Michael, and we really appreciate you sharing your valuable knowledge, and hopefully we'll see you again in the future.
Terrific. Thank you very much.
Bye-bye.